LiSTNR production.
In 2012, Brisbane father and real estate agent Gerard Baden-Clay reported his wife missing.
Police station, what's your emergency?
10 days later, Allison Baden-Clay's body was found beneath a bridge and suspicion turned to her husband. This is a story of betrayal, an outstanding forensic investigation, and a series of red flags that didn't align with the story Gerard Baden-Clay was telling police and the public. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Gerard Baden-Clay was born in South Africa and later moved to Australia. He is notably the great-grandson of Lord Robert Baden-Powell, the founder of the Scouting movement. Baden-Clay established himself as a real estate agent in Brisbane, where he managed a successful agency. He married Allison Dickey in 1997, and together they had 3 daughters. Allison was a former Miss Brisbane, a university graduate fluent in 6 languages, and a dedicated mother and career woman. On the morning of April 20, 2012, Gerard reported that Allison was missing from their Brookfield home. He claimed she had gone for an early morning walk and failed to return. A significant police investigation began, and the local community began a widespread search. A major incident room was established at the Indooroopilly police station, and public appeals were made for information. Initially, the police treated the case as a missing persons report. Allison's parents also made heartfelt pleas for assistance in locating their daughter. Ten days later, on April 30, Allison's body was discovered by a kayaker on the banks of Colo Creek, approximately 13 kilometres from their home. The autopsy could not determine a definitive cause of death due to the body's decomposition. The investigation quickly turned its focus to Gerard Baden-Clay. He was found to be having an extramarital affair with a former employee, Tony McHugh, and was under significant financial stress. These factors contributed to the suspicion that he had a motive to harm his wife. As the investigation progressed, several inconsistencies in Gerard's account raised suspicions. Key factors included that he had scratches on his face. He claimed they were from shaving, but a forensic pathologist testified they were consistent with fingernail scratches likely inflicted during a struggle. Police went through his phone and computer data. Investigators uncovered deleted internet searches on how to conceal evidence and examined his call and text activity around the time of Allison's disappearance. Then there was the location of Allison's body. It was found 13 kilometres from the family home, with no sign she'd walked or driven there, contradicting Gerard's claim she went for a walk and didn't return. Police also believed he had a financial and personal motive. He was in significant debt, had a $1 million life insurance policy on Allison, and was having an affair with Tony McHugh that he wanted to continue. There were also inconsistencies in his timeline and evidence. CCTV footage, phone pings, and witness statements pointed to gaps and lies in his version of events. These combined strands of physical, digital, and circumstantial evidence ultimately led to his arrest and conviction for murder. Following the discovery of Allison's body and mounting evidence, Gerard Baden-Clay was arrested on June 13, 2012 and charged with the murder of his wife and interfering with the corpse. He maintained his innocence and stated he would be strenuously defending the charges. His trial commenced on June 10, 2014, in the Supreme Court of Queensland. A jury comprising 7 men and 5 women was impanelled. The prosecution presented its case, highlighting Gerard's affair, financial difficulties, and the injuries on his face. It argued that these factors indicated a motive and opportunity for murder. The prosecution argued that Baden-Clay's behaviour following his wife's disappearance, including his demeanour and statements, indicated consciousness of guilt. The defence contended that there was no direct evidence linking Gerard Baden-Clay to the crime and suggested alternative scenarios for Allison's death. On July 15, 2014, after a 5-week trial, the jury found Gerard Baden-Clay guilty of murder. He was sentenced to life imprisonment with a non-parole period of just 15 years. Baden-Clay appealed his conviction, and in December 2015, the Queensland Court of Appeal downgraded his conviction to manslaughter, citing insufficient evidence to prove intent to kill. The prosecution appealed this decision to the High Court of Australia. In August 2016, the High Court unanimously reinstated the murder conviction, stating that the jury's original verdict was reasonable and that the circumstantial evidence was sufficient to establish intent. In Queensland, homicide offences like murder and manslaughter are governed by the Criminal Code Act of 1899. Section 302 details the definition of murder. A person who unlawfully kills another is guilty of murder if any of the following apply. Firstly, there was intent to kill. That is, the offender intended to cause the death of the person killed or some other person. Secondly, there was intent to cause grievous bodily harm. That is, the offender intended to cause grievous bodily harm and death resulted. And thirdly, a death was caused during another crime. That is, the death happens in the course of committing another crime like an armed robbery or rape, even without specific intent to kill. And the fourth is the death was caused while resisting arrest or escaping. The maximum penalty for murder in Queensland is life imprisonment. Section 303 of the Queensland Criminal Code provides the definition of manslaughter. If a person unlawfully kills another, but without the intent required for murder, it is manslaughter. An example would be a death caused during a physical altercation without intent to kill or cause serious harm, or a death resulting from criminal negligence. The maximum penalty is life imprisonment, but the sentencing range is more flexible than for murder. There is also what's called an alternative verdict. If a person is indicted for murder, the jury may return a verdict of manslaughter if they are not satisfied beyond reasonable doubt that the accused had the intent to kill or cause grievous bodily harm, but are satisfied the accused unlawfully killed the victim. This is exactly what happened at the Queensland Court of Appeal in the Baden-Clay case. The court found that while Baden-Clay may have killed Allison, there was a reasonable hypothesis consistent with a physical altercation gone wrong, without intent to kill. Therefore, the murder conviction was downgraded to manslaughter, though the High Court later reversed this, saying the jury was entitled to find intent on the circumstantial evidence. I'll read from the judgment handed down in the High Court of Australia, the hearing presided over by Justice Susan Kiefel, Justice Robert French, Justice Virginia Bell, Justice Patrick Keane, and Justice Michelle Gordon. On 15 July 2014, following a trial in the Supreme Court of Queensland, the respondent was found guilty of the murder of his wife, Allison Baden-Clay. The respondent appealed against his conviction to the Court of Appeal of the Supreme Court of Queensland, on the ground that the jury's verdict was unreasonable. The Court of Appeal allowed the appeal on that ground, set aside the respondent's conviction of the charge of murder, and substituted a verdict of manslaughter. The Court of Appeal held that, although it was open to the jury to find that the respondent had killed his wife, the evidence did not allow the jury to be satisfied beyond reasonable doubt that the respondent intended either to kill her or to cause her grievous bodily harm. In particular, the Court of Appeal accepted the respondent's submission, made for the first time on appeal, that the prosecution had not excluded the hypothesis that the respondent had struck his wife in the course of a struggle and that she had died as the result of a fall or in some other manner that did not involve an intent on his part either to kill her or to cause grievous bodily harm. On the appeal to this court, the Crown contended that it was open to the jury, having regard to all the evidence, to be satisfied beyond reasonable doubt that the respondent killed his wife with intent to kill her or to cause her grievous bodily harm. That contention should be accepted. Coming up, the judgment continues. Allison Baden-Clay's friends and family established a foundation in her name. It aims to build a national community that acknowledges the prevalence of domestic and family violence and seeks to create an Australia that is committed to eliminating and taking affirmative action to stop domestic and family violence. The Foundation's website says of Allison's marriage, "They seemed to have it all. But Allison was keeping a secret from close friends and family. Her husband was not the charming salesman he presented to the world, but a controlling narcissist who began isolating her as soon as they married. A man who tormented her about her appearance, told her she was worthless, was unfaithful to her behind her back, and who used their savings to prop up his failing business. For years, Allison blamed herself, trying to make her marriage work. However, more than anything, she wanted her children to grow up in a happy home, and this was her life goal." Before we get to the High Court's reasoning, it's worth remembering the weight this case carried, not just legally, but publicly. The Queensland Court of Appeal had downgraded Gerard Baden-Clay's conviction from murder to manslaughter, but the High Court would have the final word. I'll return now to the High Court judgment. The respondent gave evidence at his trial. He denied that he had fought with his wife, killed her, and disposed of her body. The respondent's evidence did not support the hypothesis held by the Court of Appeal to be consistent with the respondent's innocence on the charge of murder. The hypothesis on which the Court of Appeal acted was not available on the evidence, and so the Court of Appeal was wrong to conclude that it was unreasonable for the jury to find on the whole of the evidence that the deceased's death at the respondent's hands was intentional. The appeal should be allowed and the verdict of guilty of murder restored. The evidence at trial. The respondent gave evidence that he, his wife, and their 3 daughters were at home on the night of 19th of April 2012. He said that he went to bed about 10 p.m, leaving his wife, who was watching television, in the living room. He woke just after 6 o'clock the next morning. His wife was not at home, but she often went for an early morning walk. That morning, he was responsible for getting the children ready for school and taking them there. He was under the pump a little bit and was rushing that morning. He said he cut himself shaving. The respondent phoned and sent text messages to his wife, but there was no response. He also called his parents to tell them that he did not know where his wife was. He went driving around the suburb looking for her. At 7:15 a.m, he called 000 to report her missing. The police arrived at the respondent's home at 8 a.m. The respondent was asked whether he and his wife were estranged. He denied it. He was asked whether there was an indication that the marriage is going to break up, and he answered, I hope not. He went on to say that he had an affair that ended last year. The deceased's body was found on the 30th of April 2012 under a bridge on the bank of Colo Creek, some 13 kilometres from their home. The forensic evidence. Dr. Nathan Milne, the forensic pathologist who conducted the post-mortem examination of the deceased's body, was unable to determine the cause of death because of the significant level of decomposition of the body. But in his opinion, the deceased did not die of natural causes. There were no definite injuries found, which might have suggested the use of a weapon. It may be noted that there was no evidence of a skull fracture. Dr. Milne estimated that the time of death was consistent with the last time she was seen alive, 11 days earlier. There were no signs suggestive of drowning. Dr. Milne said that if the deceased had fallen from the bridge onto the ground, significant injuries would have been expected, but acknowledged that if she fell into the water, there may not be detectable injuries. Although the deceased did at various times suffer from depression, for which she was prescribed medication, Professor Olaf Drummer, a forensic pharmacologist and toxicologist, concluded that consumption of drugs did not contribute to her death. In addition, none of the medical practitioners or psychologists who had treated her held any concerns that she was suicidal. Leaves found on the body were from trees of 6 species that grew at the respondent and wife's home. 4 of these did not grow at the site at which the body was found. The respondent and his wife's eldest child thought that the mother was wearing a sloppy jacket and pajama pants at the time the deceased was watching television. The deceased's body was found clothed in 3/4-length pants, socks, sneakers, and a singlet top which had a bra built into it. Blood matching the deceased's DNA profile was found in the rear section of her car, which had only been acquired in February 2012. Tests on the respondent's mobile phone showed that it had been placed on a charger adjacent to the side of the bed on which he slept at 1:48 a.m. at a time when he claimed he was asleep. The respondent's injuries. 3 experts gave evidence that there were 2 categories of injuries to the respondent's right cheek. Their evidence that it was most likely that fingernails caused one set of scratches, and it was implausible that those scratches had been caused by a shaving razor. The second set of marks appeared to be different. They were fresher and were consistent with having been caused by a razor, particularly if moved from side to side as it was drawn from front to back or back to front across the face. The High Court also looked at Gerard Baden-Clay's affair. The respondent had been involved in a sexual affair with another woman, Ms. Toni McHugh, since August 2008. The affair with Ms. McHugh began when she commenced working for the respondent's real estate agency and continued until a friend informed the respondent's wife in September 2011. The respondent then ceased the affair and Ms. McHugh left his employ. The affair recommenced at the respondent's instigation in December 2011. Ms. McHugh gave evidence that, during the course of the affair, the respondent told her that he had no relationship with his wife, that he did not love his wife, that he loved Ms. McHugh, and that one day he wanted to come to her unconditionally. On the last occasion Ms. McHugh and the respondent met before the deceased's disappearance, she said she needed to know what was going to happen with respect to their relationship. The respondent told her that he would be out of his marriage by the 1st of July. He confirmed this promise in writing less than 3 weeks before the deceased's disappearance. Ms. McHugh gave evidence that she and the respondent had discussed their living arrangements between December 2011 and April 2012, and that although the respondent was willing to entertain such discussions, she said he never really got practical about anything. Ms. McHugh, referring to the July 1st deadline the respondent had set, said, "I thought he's just pulling a number out of thin air. In actual fact, I just didn't believe it. I didn't believe it at all." On the 20th of April 2012, Ms. McHugh was to attend a real estate conference. Late on the afternoon of April 19, she phoned the respondent to talk about the conference. The respondent told her that 2 of his staff members were going to attend. Ms. McHugh inferred that one of the attendees would be the respondent's wife. Ms. McHugh became upset and told the respondent that he needed to tell his wife about their relationship and that it was unfair to both her and his wife for them to be in the same room together. His response was that he was thinking of selling the business and that he would do that after he had left his wife. Ms. McHugh said she believed that the respondent was taking more of a stand and that something was going to be different this time. As noted above, on the morning of April 20, the respondent admitted to police that he had had an affair, but told police that it had ended. The respondent told police that he and his wife had seen a counsellor the previous Monday who had suggested that 15 minutes be set aside each night for his wife to vent and grill the respondent about his affair, which she thought had ended. The respondent said that he and his wife had had a 15-minute session the previous night and that there were some difficult things that we talked about. The respondent also said that their financial situation was pretty tight. Ms. McHugh gave evidence that she attended the conference on April 20. She called the respondent at lunchtime to ask him where his wife was. He told her that his wife was missing. On that day, he told her that they need to not communicate and lay low. On the 21st of April, the respondent called Ms. McHugh and told her that police would want to speak to her and that she should tell the truth. While she was with police, he called her again and told her just to answer yes or no. He asked her whether she had told the police that they were together again, and she replied yes. The call ended. Ms. McHugh and the respondent met one further time when the respondent told her that she would have to fall in love with someone else and that things weren't going to be looking good for him. In his evidence, the respondent admitted that he had told Ms. McHugh that he loved her and he had undertaken to leave his wife by the 1st of July. However, he said that he had never loved her and merely did that to placate her. He admitted that he told her that he did not love his wife, but insisted that he actually did. The Court of Appeal had proposed that Baden-Clay might have unintentionally killed his wife during a physical altercation, which could explain the circumstances without proving intent. The High Court found this hypothesis inconsistent with the evidence presented at trial, particularly Baden-Clay's own testimony denying any involvement in his wife's death. The High Court emphasised that for an alternative hypothesis to be considered, it must be consistent with the evidence and not merely speculative. The High Court underscored the significance of circumstantial evidence in establishing intent. Key factors included his post-offence conduct, Baden-Clay's actions following his wife's disappearance, such as providing false information to the police and attempting to conceal his extramarital affair, were indicative of a consciousness of guilt. Then there was the physical evidence. the presence of scratches on Baden-Clay's face, which he attributed to shaving, but forensic experts testified were consistent with fingernail scratches, suggested a struggle had occurred. And the motive. Evidence of financial difficulties and an ongoing affair provided a potential motive for the crime. The High Court concluded that this combination of factors allowed the jury to reasonably infer intent beyond a reasonable doubt. The High Court emphasised the importance of the jury's role in evaluating evidence and drawing conclusions. It stated that appellate courts should not overturn a jury's verdict unless it is unreasonable or cannot be supported by the evidence. In this case, the High Court found that the jury's decision was justified based on the evidence presented. It put forward 3 reasons. The first was that intent can be inferred. Even in the absence of direct evidence, intent to kill can be established through a combination of circumstantial evidence. The second, that alternative explanations must be evidence-based. That is, hypotheses that contradict the defendant's own testimony and lack supporting evidence are insufficient to overturn a jury's verdict. And finally, a jury's verdict holds significant weight. The High Court found appellate courts must respect the jury's role in interpreting evidence unless there is a compelling reason to question their conclusions. I'll read again from the High Court judgment. In all the circumstances of this case, other than speculating about how things might have happened, it was open to the jury rationally to conclude that the respondent killed his wife and did so with intent, at least, to cause her grievous bodily harm. Upon the whole of the evidence led at trial, it was open to the jury to be satisfied beyond reasonable doubt that the respondent was guilty of murder. Gerard Baden-Clay's lengthy legal journey was over. His original murder conviction would stand. Since his incarceration, Baden-Clay has been described as a model prisoner by some sources. He has kept a low profile and reportedly earned certain privileges due to good behaviour. However, in 2020 he was banned from working as a carer for other inmates after allegations of misconduct. Baden-Clay is eligible for parole in 2027 after serving the minimum 15-year non-parole period. However, there has been public outcry and advocacy for him to serve a longer sentence. Retired Detective Superintendent Mark Ainsworth, one of the lead investigators, has been vocal in his belief that Gerard Baden-Clay should serve more time, citing his lack of remorse and cooperation during the investigation and trial. The Allison Baden-Clay Foundation aims to honour Allison's memory by promoting education and prevention initiatives related to domestic abuse. It can be found at allisonbadenclayfoundation.org.au. Thanks for listening to Crime Insider's Judgments. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at LiSTNR Crime or TikTok at LiSTNR Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound designed by Niall Fernandez. This series was recorded and produced on Gadigal land.